nasty.
It's really important as the employer to make sure that not only that you have a separation agreement, but that it's a legally compliant separation agreement. FFCRA primarily did two things. Number one, it gave employees the right to 80 hours of paid leave. People can suffer retaliation in a number of different ways that gives them legal rights. If they bring a complaint of harassment, for instance, and the employer take action against them, that's retaliation.
Got it. Hey everyone, welcome to the first episode of the Nasty Truth Podcast. I'm going to be starting every episode with a little bit of a summary to give you guys an idea of what you can expect going into this episode. Okay, on this first episode, we have my close friend, Mr. Eric Becker, and he's numero uno. And the reason that I'm having his podcast be first is because he is an employment law specialist, and he's going to talk to you about how to deal with whether you're an employee or an employer in this COVID climate, okay? So this really pertains to anyone and everyone because everyone either has a job or they're the boss. And so he's going to talk about the laws that have developed through these last year and a half, and things that have changed over time since COVID has come into place. These are obviously things that have never been dealt with before. No one alive right now has dealt with these types of circumstances. And so whether you're cooking, cleaning, driving on the road, or if you just want to sit and watch the episode, this is going to be a great episode for you to listen into and pay attention to because it will pertain to you. So once again, tune on in. This is going to be a great opportunity for you to learn something new. All right. So hello and welcome to episode 3 of the Nasty Truth Podcast. Today we have my good friend Eric Becker here. Eric, thank you so much for being here.
My pleasure.
So Eric is a good friend of mine. Eric is actually an employment law extraordinaire. Eric specializes in all types of employment law matters. He has knowledge whether it comes from the employer side or whether it comes from the employee side. He has over 30 years experience in this field. He's done many administrative hearings. He's worked on many different types of projects for when it comes to HR, helping companies get set up, making sure they're protecting themselves from all aspects, and also, informing employees on how they can protect themselves also. On the other spectrum, he's also a member of a networking group called Provisors, which we are both in, which is a bunch of white-collar professionals that we really specialize in all our different types of fields, and I enjoy spending time with Eric there. Everybody, Mr. Eric Becker, he works for Cummins & White, which is one of the biggest employment law firms in the country, and they are fantastic at what they do, and I just want to introduce Eric, so thank you so much.
Thank you very much, Joe. I really appreciate being here.
Of course. So today we're going to be talking about our favorite topic, which is COVID. So, I'm sure everyone's sick of talking about COVID, but the bottom line is this is a new world, and it's something that none of us have ever dealt with. And this is probably the most important podcast that I've done so far, and I think it's going to be one of the most important podcasts that I do for the duration of it. Because right now, I do a lot of plaintiffs' employment law stuff, and you do a lot of employer defense stuff, right?
Right.
So we basically do both ends of the employment world. And the thing is, a lot of people right now are breaking the law, but they're not doing it on purpose, right? They just don't know what to do because no one's been through a pandemic before. So what we want to do today is we want to talk about both sides of the spectrum, okay? You're going to hear about what you should be doing if you're an employer. You're going to be hearing about what you should be doing if you're an employee, and basically what your rights are from both ends, because the rights from both ends are meant to protect each other, but a lot of people are just making mistakes because they just don't know what the hell to do.
That's true.
So what I want to start with today is I want to start with the employee side of things, just because I think there's 99% of people are employees, right? Most of the time they are not the employer. Right. So I want to give you guys a lot of good information. We want to talk about some scenarios that we've dealt with, different types of situations that, you might have been involved in the recent past. And I want you to know what you're entitled to and what you should be getting at work. So let's start off today by talking about the FFCRA. I think a lot of people have heard about this, right? And I want to kind of explain what that is and what people's rights are in regards to that.
Sure. So FFCRA is a law that was passed earlier this year in response to the initial outbreak.
And that stands for Families First Coronavirus Response Act.
Right.
If you guys see that anywhere, that's what it stands for.
I'm so used to using the acronyms now, it kind of rolls off the tongue. But it was became effective on April 1st.
Okay.
And FFCRA primarily did two things. Number one, it gave employees the right to 80 hours of paid leave if they either come down with coronavirus, they have the symptoms, or if they're subject to a quarantine order, or if they have to care for a family member who has coronavirus.
Okay, so let's talk about these 80 hours. So these 80 hours don't affect the already paid sick leave or their vacation time that they already have, right?
Right. FFCRA says an employer cannot force you to take your California mandated sick leave, the Healthy Families Act,
Got it.
or your vacation in lieu of the 80 hours. So the 80 hours kind of takes precedence over everything else.
Got it.
Have to give you that first.
Got it. So they're basically giving you, for those of you that are listening in, you get an additional 80 hours of paid sick leave. And this is protected under the FFCRA, and it's not supposed to affect your already sick leave and your already vacation time that's in there. So if they start taking that away from you when you're taking time off for either being sick from COVID, a doctor tells you have COVID, or you're taking care of a sick family member or potentially a high-risk family member, you need to make sure that they're not doing that. So I know that there's certain limitations. You can only get up to a certain amount of money, right? And it's for 80 hours. What are those limitations?
So the limitations are you get 100% of your wage replacement, but it's up to $5,150.
Okay, up to $5,150 total for the 80 hours.
Total for the amount that you get reimbursed.
Gotcha. So for all you millionaires out there, you will not be getting paid your full salary, but they will compensate you something. And I think on the company side, right, they get a full tax credit for that benefit.
That's right, and a lot of people don't understand this.
Yeah.
And this is something as an employee that you should tell your employer, look, you get to write this off of your payroll tax deposit. Most employers make their payroll tax deposit quarterly, and it's a one-for-one write-off.
Yeah.
So it's not going to cost the employer anything. Essentially, the federal government is funding this.
Yeah. So, I mean, you explain this to your boss. I know it sucks for them. They're going to have to put out the money now, but they are going to get a full tax credit for it later. And I get it. You have to make money to spend money, but this is really an incentive to try to help people keep their jobs. And it's the federal government trying to say, hey, we're trying to help all of the employers to keep their employees. And so it's another bonus like the PPP, essentially.
And not only that, as an employer, if someone does have COVID, you certainly don't want them feeling like they're obligated to come to work because that could lead to an outbreak at the business, in fact, a whole lot of other people. So from both the employer and the employee perspective, it's really a win-win.
Yeah.
As an employer, you don't want someone there for that 14 days if they have COVID.
So let's talk about, let's say that somebody catches COVID, they go to the doctor, they tell their boss, hey, I've got COVID. I need to take some time off under the FFCRA. If they get fired during that 2-week period that they're supposed to have off, what are their rights then?
Sure. So one thing I want to clarify to make sure that everybody out there understands. This is not a entitlement that you can get just because you say, wow, I have a sore throat, I must have COVID, therefore I want 80 hours off. You have to be able to show to your employer that you have taken steps to get a diagnosis, whether that's going to the doctor or going to get tested. Now, if you go and get tested and it turns out that you test negative, you're still entitled to the FFCRA for the period between you started having symptoms that could be COVID and when you go and get the test results.
Got it.
So that's important.
That's very important. So what he's saying, guys, if you go get drunk and then you get hungover and it's Monday because you've been sitting at home not doing anything for the foreseeable future, don't say that sore throat is COVID. Actually go to the doctor, get checked, and make it a legitimate reason, because you don't want to also just take off 2 weeks for no reason at all. You know, we want to try to help the economy keep going, and you don't want to take advantage of the federal government or your employers.
And if you start having symptoms, it's important to go get diagnosed.
100%.
Okay? So if someone says, look, I've got symptoms, I'm going to see the doctor, and the employer says, I don't care, I'm firing you, employees would have a couple of different options. Okay? Because that's clearly retaliation. And employees who assert their rights under the Family First Coronavirus Act are protected from retaliation.
Let's explain what retaliation is, just because I know a lot of people, like, they hear the word retaliation, they've seen it in the movies, they're like, my boss retaliated against me, that company retaliated against me. What does retaliation mean in simple terms for everyone?
Yeah, so the legal term is adverse employment action, okay? Simple terms, you get fired, you get demoted, your hours get cut, the employer cuts your pay, right? You suffer something that is not good.
Got it. And it's usually as a result of something like you haven't done anything illegal, but they retaliated against you anyways.
Right. So people can suffer retaliation in a number of different ways that gives them legal rights. If they bring a complaint of harassment, for instance, and the employer take action against them, that's retaliation.
Got it.
If they bring up a safety concern, at work,
and then they say you're fired. Yeah, I actually had a client, I had an example of one of this. Somebody called me, they said that their bosses, he was a security guard, and they were not giving them gloves, they were not giving them masks, and of course these people are coming in touch with people, they have to touch, their bodies, they have to look at their IDs, they're touching their personal items, and they were not giving them gloves, and they were not giving them masks, said they were not going to, and he complained to his boss, and then it ended up being a retaliation because he fired him the next day, and he said, we're not giving you any of this stuff because they didn't believe coronavirus was real, and so thus he got fired. We ended up settling, of course, later on, but yeah, you guys just have to be aware that employers are required right now during this time to be following certain precautions and we don't know actually until maybe the whole world goes back to normal, but you have rights. So maybe we should talk about at this time, what are some of the things that employers should be doing for employees to protect them from the coronavirus?
Well, there are guidelines that have been put in place, not just by the federal government, but by the CDC and OSHA, right, the Occupational Safety Health Administration.
I didn't know that OSHA chimed in. So OSHA's a big deal, guys. If OSHA says something, that's very important. They're like one of the highest organizations for health and regulations and cleanliness.
Workplace safety.
Yeah.
And of course, the state of California, through the governor's office, has also put a lot of mandates on employers.
Yeah.
There's a whole list of things that employers need to be doing. The primary things, the things that are most important, are number one, as you mentioned already, Joe, they need to be providing PPE to employees.
PPE means those type of masks?
Personal protective equipment.
Okay, got it.
Right? Masks, gloves in situations where people are going to be interacting with the public.
Okay. Are the employees allowed to bring their own gloves and masks?
Yeah, absolutely.
Okay.
But if employees don't have gloves and masks, the employer is obligated to provide that to the employees at no cost.
Yeah, I was going to ask you because I've heard some employees telling me that they've brought their own gloves and masks to the office, and their office said, no, you have to wear ours. Is that okay? I'm not sure. That was one that I was not sure about.
That's a good question. I think it would depend on what type of gloves and masks the employee brought.
Yeah.
Like for instance, under the CDC guidelines, you can't have a mesh mask that has openings, right?
Okay.
So if the employee comes in and says, hey, I've got this scarf, that's my covering, I think the employer would be entitled to and probably obligated to say, no, you can't wear that. You need to wear this mask because this not only protects you, it protects other employees.
Okay, so let's talk about the employees that actually, we'll flip it. So the employees that say, you know what, fuck COVID, I don't believe in this isn't real, I'm not wearing a mask, I'm not wearing gloves. Is the employer allowed to fire them?
Yes, with exceptions.
With exceptions, okay.
Okay. I say yes because it's like any other piece of safety equipment.
Yeah.
Right? If you're a welder and you say, you know what, I don't believe that sparks can fly off this welding machine. I'm not wearing the visor to protect myself.
Yeah.
F it.
I'm Superman, yeah.
The employer can say, well, then you're not going to work for me.
Yeah.
And this is no different, okay? Yeah. The exceptions would be circumstances where an employee says that they have some sort of medical condition that constitutes a disability.
Okay.
And they've got certification from a doctor saying, and I'll give you an example of one I dealt with very recently. Doctor's note says employee is suffering from anxiety.
Okay.
And can't wear a mask.
Okay.
Okay, well, anxiety is a recognized disability.
Got it.
And if a doctor says someone has anxiety, okay, you have to adhere to that. However, that does not give the employee the right to come into work without a mask.
Got it.
What it does is it triggers an obligation on the part of the employer to engage in, I'm going to use another legal term, sorry, the interactive process.
Okay.
Which is sitting down with the employee and saying, okay, you can't wear a mask. What can we do to accommodate you that would still allow you to perform your job?
Got it. So this is almost like a disability, right? Let's say somebody was missing an arm or a leg to be an extreme disability, and then they have to accommodate this person because of their disability. So the anxiety would be almost designated a medical disability. Is that correct?
Correct, yeah.
Got it.
So in that circumstance, one of the things that we said to the employee is, look, if you can't wear a mask, we do have work available for you at home and we can assign you at home.
Okay.
Now, does the employer have to assign you to home?
Got it.
The employer can say, look, you can't perform your job at home. You're a welder. I'll use that example, right? You can't weld at home.
No, you can't take it there.
I can't accommodate you by letting you work at home.
Yeah.
So therefore, if you can't wear a mask and I'm asking you to come to work and there's no other accommodation like putting you in a separate office or isolating you from other employees, then the accommodation would be you're going to go on an unpaid leave of absence.
Got it. Okay.
Now, so that's important for employees to understand. In that circumstance, they can't get fired, but they don't have a right to go back to work without a mask and therefore put in jeopardy the safety and health of other employees.
Got it. So it's really depending on the circumstance, right?
Yeah.
Like depending on what your job is. But like, for example, another example could be that you could just say, if it is an option, you can send that person home with a laptop and they can do their work at home with a laptop. So that's like extreme spectrums. You can only weld where the location is. If you're going to put other people in risk, we're not going to have you there. And so the unpaid leave of absence, I know a lot of people right now are getting furloughed. And some people are getting unpaid leaves of absence. Do we want to maybe explain what the differences are between getting fired, unpaid leave of absence, and getting furloughed?
Yeah, and this is, we had back in April, I don't know how many discussions with clients about furlough and what's the difference between a furlough and a layoff and everything like that. So termination means your employment's terminated, right? You're done, okay? A leave of absence, whether that's a leave of absence under one of the protected leaves of absence like FMLA, Family Medical Leave Act, or just an unpaid leave of absence that the employer grants you, does not terminate your employment. You're still an employee.
Yeah.
Okay? And depending on the leave of absence, you may or may not be entitled to unemployment.
Okay.
Okay? In a furlough situation...
So there are leaves of absence where you can still get unemployment. Can you maybe give some examples? Because I'm sure some people are out there probably wondering if they are entitled to it. Because I know I've had several friends tell me that they've been not let go, but leaves of absence, and they don't even know if they should apply. And so what would be some scenarios where they could?
Well, in specifically dealing with COVID, if you're put on a leave of absence due to COVID, there are programs where you can either get disability from the state or you can get unemployment from the state.
Okay, got it.
Okay, so that would be an example of where you would be entitled to some sort of wage replacement, right?
So let's talk about where do people, if they are going to go apply for that, where do they go apply? Is it just like the EDD, right?
Oh God, yeah, the EDD.
And guys, for anybody that calls and asks us, just Google it. Really, most stuff you can figure out if you just Google it. You don't need to call an attorney. And, the times you want to call an attorney when it comes to applying for unemployment and so on and so forth is going to be if there's an appeal or if you got rejected, and then you need an attorney to review it and help you resubmit it. But otherwise, it's just a form. It takes some time. You need to get all your stuff together, and then you need to just kind of go through the motions. And for all of you that have not been applying for it, the government is trying to help. They're giving everyone a boost right now. I think it's $600 boost a week, right? Up until
that expired actually.
That just expired.
Yeah. So now they're talking about $300 a week, which is something the president put in as a executive order.
Got it.
It's questionable right now whether or not that $300 extra, but that's on top of what you're already entitled to.
The normal entitlement, yeah.
Exactly.
Understood, okay. Because typically I know everybody, right, I mean personally, just to be very frank with a lot of people, I know a lot of friends that aren't even looking for a job right now just because they're making almost more money because of this $600 a week boost, which is, it's great, but we're going to feel it later is basically what's going to happen because a lot of people have gotten lazy and they're not working. They're sitting around. They're like, the government's just paying my bills anyways. They're watching Netflix. They're playing Call of Duty all day, every day. And they're like, why am I going to go into work to make less money?
Right.
And, that's a whole different conversation in itself. You need to find your purpose and your motivation in life, and you need to figure it out. But at the end of the day, people need to wake up and realize this is coming to an end now, or sooner rather than later. This will not last forever. And you need to start thinking about your next steps, because what's going to happen is you're going to then lose that bonus. You're going to be sitting there not being able to pay your bills, and then I don't know what your next steps are, but it's going to get very desperate for you very quickly.
Yeah, and sooner or later, EDD is going to say, what have you been doing to try to go look for employment? And if you can't prove that you're looking for employment, you're going to get cut off.
Yeah, I mean, for all of you out there, it takes, an hour every single day. You're not doing anything for 10 of those hours except for watching Netflix and playing Call of Duty. Just apply to some jobs, go in for some interviews, try to find some motivation. Some of the greatest minds in history have come out of great recessions, right? Yeah. They see something that is drastically wrong with the world, something that needs to be fixed. They take this time and they focus on it, right? Even if you spent 2 hours of your day trying to find a problem and something that you can fix, you might change the world. And I know that's a very extreme example, but even if you just found something that you're interested in, a hobby, read a book, do something. Don't just sit around and waste this time. COVID has been a great time for me where I've gained back hours every day instead of having to drive to meetings, go to networking things in person and meeting clients in person. I do everything from my home office now, and I've gained back 10 hours every week where I'm reading more, I'm exercising more, and it's really, this is a time that you should be expanding your knowledge and expanding your health, not regressing just because the government is paying your bill.
Make yourself more marketable.
Make yourself more marketable.
Because that's what it comes down to. If you have more skills, if you have more experience, you're gonna get ahead of everybody else when you are out looking for a job. So
absolutely.
Yeah.
So let's segue back to where we were. So we just finished talking about leave of absence, and we talked about that you can get unemployment per chance under certain circumstances. Now we want to talk about what it means to be furloughed. Because furloughed is a tough one. I've been dealing with it with a lot of people calling me, and I'm getting 20 leads a day for COVID, getting fired type of situations, getting furloughed type of situations, and people don't know what their rights are. So I want to kind of tell people, what are your rights if you've been furloughed, and what does it mean?
Right. So furlough is really a fancy term for a temporary layoff. Okay. Of usually of a definite duration.
Okay.
Right. So if someone,
when you say usually of the definite duration, it means you're probably not going to get rehired.
No,
right?
I mean you probably will be rehired.
Okay, you probably will be rehired.
Right. A permanent layoff is when the company says, look, we don't need you anymore. We're laying you off. We don't anticipate you coming back. Right? That's equivalent to a termination.
Got it.
A furlough is more like, look, we've got COVID. We hope to be reopened within 3 months. So we're going to furlough you for 3 months.
Got it.
That's what I mean by a definite duration.
Oh, definite duration.
It's a layoff, but it's supposed to be a temporary layoff. Now, the reality of it is there's a lot of people who have been furloughed that are never going to come back.
Yeah.
Okay, we know that.
Yeah.
Then it just turns into a permanent layoff.
Yeah, and I want to make a comment there too. For the people out there that think your bosses were looking for an excuse to fire you and they just furloughed you, take that into consideration. They shouldn't be doing that, but there are probably moments where that probably is your reality, because people are restructuring. They're having opportunities to let people go without having to fire them. If you've been furloughed for 6-7 months now, this is the same conversation I had 5 minutes ago. You need to start looking at other options at this point, because a lot of companies just aren't going to make it either. A lot of people are shutting down.
Yeah, or they're just going to run a lot leaner than they did before.
Yeah.
Now, in a furlough situation, generally speaking, people are not going to have any type of legal claim, right?
Okay.
However, if your company was picking and choosing who they were going to furlough, okay, you've got 5 people in your department, and we're going to take you 2 over there, and we're going to furlough you. You 3 we're going to keep.
Okay.
And let me just give you an example. And the 2 that got selected for furlough just happened to be the 2 employees that are age 65 or over.
Got it.
Then you might have a situation where your employer was engaging in some form of age discrimination.
Got it. So let's explain that to people. So you have certain civil acts under the Civil Rights, or certain rights under the Civil Rights Act. Okay. So one of them is protections for disabilities, race, culture, sex, gender, a lot of these protected rights. And so one of them is age.
Correct.
So I actually had a case like this similarly too, where they basically, due to COVID, they took advantage of COVID. They let go of half of a department. It just happened to be that 80% of those people were all over the age of 55 to 65.
Yeah.
And it basically, they're taking advantage of it, and they're discriminating based of age. They want to get a new younger generation in, which is completely illegal, and they can't do that. And so I'll let you continue.
Yeah. So from the employer's perspective, when you're selecting people for furlough, you have to have objective reasons that are not just, oh, the guy wasn't a good worker, or, oh, she didn't do, it's got to be objective, okay, based on documented job performance or skills or experience when you're determining who you're going to select for furlough.
Yeah.
And in a situation where the employer can't come up with that, and I heard these buzzwords all the time.
Yeah.
Oh, well, it wasn't a team player.
Got it.
Or, just didn't have the right attitude. Well, those all sound like cover-ups for you wanted to get rid of your older people.
Yeah.
Which you're absolutely right, is illegal.
Yeah.
Okay? And if I'm an employee in that situation, I certainly would want to explore the possibility of at least talking about filing a claim, because if the employer didn't offer severance, these are expensive cases to defend.
Yeah.
And likely, if you get a lawyer to write a letter on your behalf, as you said earlier, Joe, you could possibly get a settlement. Most employers in the situation, however, and I have been advising my clients, look, if you're going to go through a furlough where you're permanently laying off people, you really should offer some sort of severance in return for the employee signing a separation agreement which says, I'm waiving my rights to sue you.
Got it. So I want to talk about two things real quick, and then I want to continue it on this road. So for all of you, when he said objective, so you need an objective set of standards. So let's talk about what the difference between objective and subjective is for people that don't understand. So subjective means when it's based off of like your own point of views, right? Objective is where you have a set list and you go, okay, these are the criteria for whether you're going to keep an employee or not. This list is always the same. It never changes. It's not based on the person doing the interview and what their views are and what their biases are. So you always want to use objective whenever you're letting somebody go or you're hiring somebody. And this is why when we come in as an attorney, the first thing we do is give me the employee file. I want to see how you hired him, why you didn't hire him, why did you fire him, what are the reasons, did he ever act bad, or is it just because, of his age?
And was it documented? Okay, this is the thing that drives me absolutely crazy as a representative of employers.
Yeah.
Okay, it is not enough for you as an employer to have emails.
Yeah.
It is not enough for you to have some scribbled notes.
Yep.
Okay, when I say documented, there needs to be something formalized where if an employee is not meeting standards, they're doing something wrong, whatever it is, they don't have the skills, you've got it in writing in a formal document that you shared with the employee, and you've given that employee an opportunity to correct whatever it is that's a problem. If you don't have that as an employer, there aren't objective basis for your employment decision.
And this is where I stick it to them every single time, because they literally make up a file. They'll literally put something together. They'll slap all the emails and like text messages between them, and there's nothing else. And there's like the sign up W-4s and the initial employment documents, and that's all they have. And it's not, you have to give, like you said, objective reasons as to why this occurred. And a lot of times you just can't do it. So let's go back to where you were now that we've explained that. I want to talk about severance. So is severance, everybody hears severance, and when people get fired, they didn't give me a severance. So are you entitled to a severance?
No.
What is, so that's a good start.
Easy answer,
No. So, if you do get one, can you negotiate one in your deals? Why do you think they should? You said it so you get a release. So let's talk about that a little bit.
Yeah, it's a really good topic. So severance is not guaranteed unless you've negotiated an employment contract, and usually this is like CEO level, where there's severance baked in the cake, right?
Got it.
Severance is negotiable. There is no set amount of severance that has to be offered or that the employee is entitled to. A lot of employers use a standard like 1 week of severance for every year of service.
Okay.
But that's not set in stone. Right?
Got it.
So if your employer comes in and says, hey, sorry, we have to lay you off, we don't have your position anymore, we're offering you a month of severance.
Got it.
You don't have to necessarily accept it. You can say, you know what? I want 2 months.
Yeah.
I want 3 months. It's negotiable.
Yeah.
Okay.
And on top of that, if they've been doing some shady stuff, right, you can really hold that over their head. I definitely have had that with several clients where they're like, I know you've been cutting on taxes for the last 10 years here, here, and here, and then, which is not, right a lot of times, but these are search scenarios. So you want to make sure, once again, you're doing a good job with your clients. You're not just firing them for no reason, or your employees, sorry,
right.
and you give them severance when they're deserving of it.
Or going back to our scenario that we talked about with the 5 people and 2 of them are over 65 and they're the ones that end up getting furloughed. Yeah. That's a situation where if I was an employer, I would be saying, I need to offer severance.
Yeah.
And if I'm an employee and they're not offering me severance, I'm going to be saying, hey, look, I don't really think it was quite fair that the only 2 people that got laid off were the ones over 65. And oh, by the way, who've been here the longest.
Yeah.
And that gives you leverage and negotiating power.
Yeah.
Now, what an employer gets in return from offering severance is an agreement from the employee that basically says, and this is the important part, I'm waiving my rights to sue the employer for employment-related claims.
Got it. It's like a waiver of liability. For those of you that don't understand that, it's like when you go and do an extreme sport and you sign a waiver, it says, I know I'm playing an extreme sport, I'm not going to be able to sue you. So basically, by getting a severance, you want them to sign this agreement and you're waiving your rights to be able to sue them for anything that may or may not have been done wrong or illegally.
So 2 things I want to say about that. From the employer side, you should never, ever offer a severance without getting a separation agreement. And I run into this all the time. Well, we gave him a month. Yeah, but you didn't get a separation agreement. Yeah. He's still suing you, and he gets to keep the month.
Yeah.
Right? Okay, so it's really important as the employer to make sure that not only that you have a separation agreement, but that it's a legally compliant separation agreement. You can't just scratch something out on a piece of paper or download it from the internet.
Yeah.
Okay, because if you don't have certain things in there, your separation agreement is not going to be enforceable.
Yeah.
That's number 1. From the employees.
I want to pause.
Oh, sorry, go ahead.
Oh, you're fine. Let's talk about downloading from the internet. I know all of you think that Google will give you the answers to everything. Those form templates that you're getting a lot of times are not protecting you for what you specifically need. Let's be very clear about this. You should always consult an attorney. You think spending the $300 for an hour of an attorney's time is not going to be worth the tens of thousands or if you're a huge corporation, the hundreds of thousands of dollars that it's going to be a pain in your ass later. Let me tell you, you are SOL. You need to consult an attorney anytime there's a legal document because Google is not always the answer. And these form rogs, for example, that you get for like wills and trusts, Rocket Lawyer, all this stuff, they are not going to hold up in a court a lot of time, and you want to make sure that somebody actually tailors it for what your needs are. I'll let you go ahead.
Well, and the other thing is a lot of times people download off the internet and they're downloading from some other state.
Yeah.
Well, California is special, as we all know.
Yep.
And we have a lot of special rules here.
Yeah.
And if you're using something that works in Texas, that, for instance, has a non-compete in it, it's not going to be enforceable in California.
Yeah,
so
let's real
be
quick
very
on that.
careful.
I want to let people know, California, non-compete clauses are non-enforceable. For all of you that think they are, listen to me. They are non-enforceable. So for all of those employees that when you get a threatening letter from your boss later saying, you sign a non-compete clause, you can tell them and give them the bird and let them know, hey, this is non-enforceable in California. But this is also why people don't understand. This is why I can only practice law in California. I passed the California bar because there's state-specific laws. This is why you have to take the bar in each state because there's specific laws in each state. And you want to make sure you hire an attorney from that state to help you with your matters in that location.
Right. Second thing I want to say from the employee side of things.
Yeah.
If you get an offer of severance, unless it's really, really low ball, my advice to employees, and I take calls from employees all the time who are trying to figure out should I take this or not. Look, a bird in the hand is always better. Unless you have a really, really, really rock solid case against your employer.
Like a smoking gun or something.
Take the money. It's better in the long run because as of right now, it's going to be 3 years before your case ever sees the inside of a courtroom.
Got it. Yep. I agree.
And getting 2 months or 3 months of pay that can help tide you over until you get your next job is way more valuable.
Yeah, let's talk about 3 years before you get inside a courtroom. I filed a lawsuit in Riverside 4 months ago. It has still not been accepted by the clerk of the court. So COVID, for all attorneys, it's effed up our lives, especially the trial attorneys. So let's be very clear about this. Litigation is slow, so it's always better to take what you're guaranteed sometimes. Well, I mean, depending on the situation, but most of the time it's better to take what's guaranteed than to wait 3 years to maybe get a little bit more after you spent 10, 20 grand on expenses. So I want to segue into a topic that I think is very important, probably one of the most important things when it comes to employment law that a lot of people just don't understand. They hear the word, they hear at-will employee, and they go, I am an at-will employee. I understand. No, you don't understand. We're going to break down what does it mean to be an at-will employee, and what are the few exceptions, like CEOs and time clauses, and you have to be fired for good cause. We're going to explain those, but I think this is extremely important, and you guys need to know what this means, because this will explain a lot of your rights as an employee and what you're guaranteed and what you're not guaranteed. So let's talk about what it means to be an at-will employee.
Ooh, at-will employment. Yes, you're absolutely right, Joe. One of the more misunderstood, if not the most misunderstood concepts in employment law.
And 99.5%, by the way, of people are at-will employees.
Yeah. At-will employment basically says that there's no contract of employment. There's no written document that says we are going to employ you for 1 year or 2 years or 5 years. In other words, the employer has the right to terminate you without breaching a contract, and you have the right to quit without breaching a contract. The whole concept of at-will really became relevant back in the 80s when I first started practicing law, because there was a case that came out that said that you can sue an employer for wrongful termination based on breach of contract, even if you don't have a written contract.
Okay.
And for employers, everybody said, oh, this could be a problem. We better start making it very, very clear in our handbooks and our written documents with employees that there is no contract of employment.
Okay.
The only thing that at-will does is say there's no contract of employment.
Okay.
It does not give employers the right to terminate anybody for any reason at any time.
Okay.
All it does is gives the employers the right to terminate and not be subject to a breach of contract lawsuit unless there is an actual, like you said, for a CEO or someone like that, or a baseball player, a contract.
Yeah, so
a written contract.
Like a contract, guys, means like, I mean, it can be anything. Well, it can't be anything, but essentially it's, you usually get hired as a high-level executive or sports player, somebody where you're told, because you're usually getting stolen from another company a lot of times, or you're this huge CEO that's made millions for another company and they want to hire you, and they're going to say, hey, quit what you're doing. We're going to pay you $2 million, come work with us for 2 years, and they're guaranteeing you a certain amount of money.
Yeah, and that's something that the CEO is going to want to demand in order to leave their current job and go somewhere else. I want that security.
Yeah.
Most people don't have that ability.
Yeah, it's because usually a lot of times they're making a certain amount of money in one place, and you have to really entice them to break their contract or to leave where they're at and to come to you. And also it gives them, a lot of times it gives them guarantees, stock options, but that's a whole different conversation.
Right. So the bottom line is that for an employee, yes, you can be fired. But the reality of it is the employer's got to have a reason. Okay? Because if they don't have a reason, then that opens the door to a claim based on any of the various laws that protect employees here in California.
Okay.
So the way I always frame it for employers is, look, this is California. The criminal standard is innocent until proven guilty.
Yeah.
In California, you're guilty, you got to prove yourself innocent.
Got it. As an employee.
As an employer.
Employer, got it.
Right. The employer is, under California law, is always going to be seen as having violated the law.
Got it.
Now prove that you didn't violate the law.
That's very interesting. I'll have to definitely think about that next time.
Well, let's just take a straightforward discrimination case.
Makes sense. I've never framed it like that before. No. It makes a lot of sense, yeah.
Right, because if you're an employee and you say, for instance, I was discriminated against because of my age, what do you need to prove at the outset of the case? That you're over the age of 40.
Yeah.
Because that's what's protected from age discrimination.
Okay. So for everyone out there, 40 years old is age discrimination.
40 years old.
Okay.
I'm over the age of 40. I suffered an adverse employment action.
Okay.
I was fired, I was demoted, whatever. And there's some connection. It doesn't have to be really well defined, just some connection between my age and the termination.
Yeah.
That's it.
Yep.
Now the burden falls on the employer to prove that it had a legitimate reason unrelated to your age for terminating you or demoting you or whatever the case may be. That's what I mean. As an employer, I got to prove my innocence because the presumption is I'm guilty.
Yeah.
So that's where a lot of employers really misunderstand at will. Like, well, it was an at-will employee. He was at will. Doesn't matter. Okay? That's not a defense in a claim of discrimination, in a claim of retaliation, in a claim of whistleblower, any of that stuff. So at will doesn't, you got to have it as an employer.
Yeah.
As an employee, understand that just because you're an at-will employee, you don't give up your rights to file a claim against your employer if they did something wrong.
Yeah, I mean, I always joke with people. I tell them, you're an at-will employee. Your boss can fire you because the sky is blue. He can fire you because you smell, because he doesn't like your attitude. But he can't fire you because of one of the protected rights. So what I want to kind of do right now is give a couple examples, something that the viewers can kind of take home so they can understand. Let's talk about some of the protected rights. So let's talk about maybe like male and female. So your gender is a protected right, correct? So if you don't get a job because, most hostesses are females, let's say at a restaurant, and you can see that it's all females working there and there's not one guy, but you qualified and it was objective, you might have a case because they should have hired you. It seems like they're being, discriminatory just hiring a bunch of females. Does that sound right?
Yeah, sure.
Okay.
Maybe, and the employer would have to prove that being female, here's the legal term, is a bona fide occupational qualification.
Got it.
Okay, which is very hard to prove. So.
Yeah. Let's also talk about like restaurants, because I know some restaurants require you to wear like certain outfits, right? And so I know that there's exceptions because you're not supposed to like tell people what to wear typically, but they're considered costumes or they're considered, let's say, uniforms, right?
Yep.
So let's talk about the difference between a uniform and a costume, because you'll see sometimes uniform like at Cheesecake Factory, right? You have a uniform, but then you'll see like at a restaurant where girls are wearing, let's say, something a little bit more scandalous. So like how can you go about doing that if you are an employer legally and so the employees know that they're not getting screwed over?
It's tough as an employer.
Okay.
I mean, this of course are the Hooters cases, right?
Yeah.
I mean, that's, as an employer, you'd have to show that the costume is an integral part of your business.
Okay.
And that there is no accommodation that would not be significantly harmful to your business that would allow men to work in that particular position.
Okay.
I mean, in most circumstances, the employer is not going to be able to get away with saying, well, we can only hire women because our costumes can only be worn by women.
Got it.
The same thing goes with religious accommodation, which is where this comes up quite a bit.
Yeah.
Right? Unless you can show something like safety.
Yeah.
Right? You're in a manufacturing facility and wearing the hijab poses a danger because it can get caught in a machine and pull the employee through the machine.
Yeah.
Unless you have something really tangible like that as a concern, you're not going to be able to get away with saying, well, we don't allow people to wear that.
Got it.
You have to make that religious accommodation.
Okay, understood. Let's talk about like maybe a disability such as, you're missing a leg, right? Mm-hmm. And you can't stand at a cashier. Maybe like, let's say you work at Walmart or you work at Target. What is an accommodation that they can give you? Can you sit at the door, at the exit, maybe be a greeter, sign, mark those receipts when people are leaving, right?
Well, yeah, or a reasonable accommodation would probably be giving the employee seating. Okay. If they're a cashier, where it gets, so the way it works under disability law is that you have to provide a reasonable accommodation that would allow the employee to be able to perform the essential functions of the job. That's the legal standard.
Got it. Essential functions of the job.
What that means is that in a situation where an employee cannot perform the essential functions, even if an accommodation is made, then the employer does not have to either give them the job or keep them in the job.
Got it.
The example I always use is, let's say you're a truck driver and you have a back injury. And your doctor says you can't sit more than half an hour at a time. Mm-hmm. Well, if you're a driver of a big rig, it's an essential job function to sit for more than half an hour. Is there any accommodation that would allow you to perform that essential function and sit more than half an hour? If the answer is no, then the employer really there's nothing the employer can do in that circumstance other than offer you an alternate job for which you're qualified.
Got it.
That you might be able to perform the essential functions of that job. So that's how that works.
No, that's. I was going to ask a similar example. I was going to say, imagine you want to go work in construction, you're missing a leg, or you want to be a carpenter and you really need to walk and carry, 100-pound things, 50-pound things all the time. If you can't physically do the job, do they have to give you that job?
No, because you can't perform the essential functions.
Got it.
Right?
Okay.
And then we always get into what is an essential function and what is not essential function. Bottom line for the employers out there, be very, very careful when it comes to dealing with disabled employees.
Yeah.
And in California, I want to tell you, almost everything's a disability.
Yeah.
It's a very, very broad definition.
Yeah.
Don't just assume. There are certain things under the law that you have to do as the employer, and you need to check those boxes.
Yeah. I mean, I want to make a comment on that too. Just really the best advice we can give you is, once again, not just because we're attorneys, just call an attorney and ask. It's worth 1 hour of your time, even 10 minutes of your time is really what it's going to take, because the risk of you violating someone's rights because they're disabled is much higher compared to just calling someone and double checking. If you run a business, if you are an employer, you need to have an attorney on speed dial for all of these situations just to double check and make sure, because sometimes it's as simple as, having the right forms, having the right documentation, and it's something that you can make part of your processes. And if it's part of your process, then you're not gonna have to worry about this headache later. But a lot of times they don't have a process, right? You're a boss, you're figuring it the hell out. You're wearing 20 goddamn hats. You're the marketer. You're the person out there doing sales. You're doing intake. You're hiring the new people. You're filling out all the paperwork. You are doing everything. It's just you and another employee, but you don't realize that you're doing things illegally. And it's not because you're an asshole. It's just because you don't know. And it's okay. And that's why you need people to help you and really give you the information that you need so that you can understand what the right things to do are.
Here's what I hear from employers all the time. I've been in business for 20 years.
Yeah.
We've been a family.
Yeah.
I've never had a problem before.
Yeah. Ignorance is bliss, right?
Today's your lucky day. And I always tell people, look, I've been driving on California's freeways for God knows how many years, and I speed like everybody else.
Yeah.
And you know what? Knock on wood, I haven't had a ticket in quite some time, but you never know when today's your lucky day.
Yeah.
And so you have to be prepared for that.
Yeah. I mean, look, guys, I'm going to be honest with you. I'm an attorney. After having this conversation today, I realize there's probably a couple things that I need to change about my processes, and it's nothing wrong with that, right? It's if progress makes perfect, right? Or perfect makes progress. It's just like over time, practice makes progress. So over time, you keep getting better and better. If you improve 1% every single day, you'll improve compounding hundreds of percents every single year. So it's not about being perfect right out the gate. You want to do the best you can, but you want to always remember that there's more that you can learn and more that you can do. One of my favorite sayings is, I know nothing, because I always feel like I'm an empty cup. Yeah. And that means whenever anybody comes to me with new information, take it, learn from it. You might not accept everything they say, but a lot of time people are trying to help you, and you got to assume that people have good intentions behind what they're doing. And if they're trying to help you and give you good info, take it and learn from it. For anybody out there that is listening to this podcast is extremely important, because you are either an employee or you are an employer. This applies to you in one way or the other. And it's really good to know both sides of the coin, because you have to also remember at the end of the day, like, your boss is, hopefully he's not just some a-hole, sexually harassing you and doing something creepy and bad. And hopefully he's just some guy trying to, help you and you help him and promote their business. And if that's the case, it's good to hear what their mentality is, and it's good to hear where you're coming from, so that both people can, have an open conversation and find a way to come to some reasonable, resolution at the end of the day.
Yeah, absolutely. And I think that's where a lot of employers and employees miss the boat. Everybody wants to arm up and, get a lawyer and, start hurling accusations.
Yep.
A lot of times you just sit down with people and have open and honest communication.
Yeah.
Right. There's a phrase that clear is kind.
Yeah.
Right?
Clear is kind.
Clear is kind. Being clear with people, not pulling punches, telling them exactly what your expectations are as an employer, and as an employee, clearly, not emotionally, but just very clearly expressing what your concerns are, and not just complaining, but providing solutions.
Yeah.
that can take care of 95% of the problems that happen in the workplace.
No, I agree entirely. This is a piece of advice I give to all the employers out there. There was a business coach, I think his name was Bill Campbell. He was like the business coach for Google and a lot of major corporations. He said that he always had told his leaders when they go into a meeting, and I do this every week, the first thing I tell my team is, what is something that I am doing wrong that I can fix to make your lives easier? Because a lot of times the boss never asks what they're doing wrong. They just accuse everybody else of being wrong. But the truth is, like, it's your job as the leader to help everybody else, because if you help them, it's going to help you. So it's super important, if you are the employer, talk to your team and ask them what are the things that can be improved. And you'll be amazed, because it's usually the person that is doing the job that you don't want to do that has the most suggestions. And those are the people that are doing the most actual like work.
Yeah.
You need to listen to them.
Yeah.
They have so much to tell you. They have so much, and they want to help you, because when you help them, they help you, and everybody's happier. You know, you want to pay everybody because the company's doing better. You're doing better, so you're making more money. It's like a circle, and you have to remember, everything is just, it's a little ecosystem. If your ecosystem starts from the top and goes down, that's hard. It needs to go from the bottom and go up, because those are the people dealing with the real problems in your company.
And you have to have a culture where you value people pushing back,
Yeah.
and giving you feedback,
Yeah.
and you don't get it, and you're not automatically defensive.
Yeah, and one other tip
very
too,
important.
Reach out to your customers. You know, so you have an email list. Everybody has an email list. I don't know how else you make business if you don't have an email list. Get your email list, send everyone an email, they have job forms, and they have free stuff online, jobform.com. You can create your own thing and just send it to your people and be like, hey, can you tell me one way I can improve my company? And now if you have thousands of customers, you just got thousands of suggestions on how to make your business better. So start from the bottom and go up, because your customers and your employees that are doing the hard work every single day, the ones that are the lower level ones, and not to call them lower level, they're just the entry people, right, that are dealing with the customers the most, they're going to give you the best information. Really try to focus there, get that info, and improve your business from the ground up.
Yeah.
Yeah.
So I guess we got kind of far afield from COVID.
No, you know, it's okay. It's all part of the process,
Yeah,
right? Like
that's
COVID's kind of just one aspect of being an employer and employee, and it's just what's current now, right? And you guys realize your bosses, they just don't know a lot of times what to do right now. Suggest for them to speak to an attorney before they fire you. Just be like, why don't you double check? You know, you can reach out to Eric Becker. He's going to give all of his information at the end, and your boss can go ahead and reach out to him and talk to him about it. There's, you know, thousands and thousands of employees or attorneys out there that are willing to help.
Here's how not to do it, okay? And this happened with one of my clients. Female employee had symptoms of sickness completely unrelated to COVID.
Okay.
Didn't go see a doctor, didn't go get tested. She was out for, I don't know, a week and a half.
Okay.
Comes in, brings in something she printed out from the Department of Labor on FFCRA, and goes into her manager's office, slaps it down on the deck and says, "You have to pay me."
Got it.
Don't that's not the way to approach it.
Yeah.
Okay? If you have a question like that, say, "Hey, I was out. Is there any way that I might be eligible for FFCRA? This is what I understand the law says." Don't just make demands like that, because you're automatically putting your employer in a position where they're going to be defensive and they're not going to want to work with you, because maybe there's another way for you to get paid other than FFCRA, but by just making it an adverse communication, it doesn't do you any good, and it doesn't do your employer any good.
No, for sure. I mean, you always get bees with honey, right? That's really the same. It goes too with my business. I mean, I deal with lots of attorneys that deal with adjusters in a super aggressive fashion. I'm like, no, just speak to people kindly. Remember, they are your bosses. At the end of the day, the person holding the check is the person you need to be kind to, because they're the ones that are going to pay you. And, even if you get an attorney, you're going to have to wrench it out of them, because now they don't like you. Now they don't want to give you $1, and they almost would rather spend 20 grand until you and your attorney run out of money just to not give you $1. So just remember that. At the end of the day, it's always important to be kind to the person with the checkbook.
That's right.
Yeah.
Absolutely.
So what I want to do now is I kind of want to segue. I want to talk about you a little bit. Let's talk about, one of my favorite topics is always ask people, what are some of the worst examples of clients you've ever had? And, not to put our clients on blast, but just kind of like some things that you've learned from them, some extreme situations that I've changed my processes many times because of clients that I've had and the way that I've had to deal with them. What are a couple examples of some clients that helped you change the way you do things now?
Yeah. Yeah. I would say that I do a lot more pre-screening of clients because, frankly, I'm at the point in my career where I don't like dealing with crazy.
Yeah, I mean, you work with some pretty big clients. Guys, he represents Hoag Hospital. If you don't know what Hoag Hospital is, that is the #1 hospital in all of Southern California, and he is their representative. So he is a big shot. He knows what he's doing. So I'm sure you picked the right clients now at this point.
Yeah, and when clients call me up and, for instance, say, I didn't do anything wrong, and I want you to, just destroy them. That's not the way to get the right outcome.
No, that's always my favorite.
Because almost always as an employer, you did something wrong.
Yeah.
Now, a lot of times, as you said, Joe, it's not that they intentionally did anything wrong.
Yeah.
Okay? But when someone comes into me with that attitude, it's like, look, you don't want me to resolve your problems. You're just looking for an emotional release. I'm going to sick my lawyer on him. And that's not the way to get to where you need to be as an employer because there's too much at risk as an employer.
No, I get it. And my favorite thing is when somebody calls me and says, I didn't do anything wrong. I know they've done something wrong. The second they call me and they say, I have not done anything wrong. It's like, you guys have to remember, everything you say has psychology, right? You can insinuate things just by the words that you use. The quality of words in your life will determine the quality of your life. And a lot of times when you call someone and you say, I didn't do this or I didn't do that, it's like you're already putting in their mind that you did do this and you did do that, right? Like, come calmly, have a conversation, bring all the evidence. Like, a lot of times I tell my clients it's super important to put together a timeline from beginning to end, put together all communications, all evidence. Like, for anybody that's ever seeking for an attorney, this goes for employers or employees, put together a timeline starting from the day this person was hired to the day you were let go or maybe not let go to the day of the incident, any communication, anything that might relate to this, because whether you do it before you get in contact with us, we're going to ask you to do this. So this is a very important part of the process is we need to see everything face to face, and your interpretation of something might be different than somebody else's interpretation of something. So you want to really bring everything from text message to email communications, letters, whatever you might have in the company. Okay.
Absolutely. So as an employment lawyer, I have crazy clients, but I also deal with a lot of crazy situations.
Yeah.
I mean, it just goes to the territory, which actually makes it interesting, right? So we have a joke in my family that I'm the urine lawyer.
The urine lawyer?
Because I had a series of situations where employees were doing various things, like just being on the line at a production facility, turning around and just peeing in a hole.
Yeah.
And going, what's the problem? Why did I get fired?
Oh, man.
Or this is my favorite. I had one situation where
funny.
this woman, of course, all names will not be shared, right? This woman would sit at her desk in her chair, and every day she'd pee in her chair. And she wouldn't get up to go to the bathroom.
I don't understand. Why? Was it disability or just like out of
No,
spite?
that was the thing, because that was my initial thought was, wow, this is like a disability situation.
Yeah.
So, engage in the interactive process with her. Do you have some, a condition? No, I just don't want to get up from my chair.
Oh, man.
Bathroom's too far away. The bathroom was like, I don't know, 20 feet away.
Yeah.
And it got so bad that, obviously other employees were complaining and they had to keep changing out her chair. And finally I'm like, look, this is an OSHA issue, right? You've got biohazards in your workplace. You can't
do this.
You can't do this.
Yeah.
She's got to go.
Yeah.
But that was the most bizarre situation because there really wasn't a reason why she couldn't just get out of her chair and go to the restroom. So, I am the urine lawyer.
That's really funny.
Yeah, so
if you guys need the urine lawyer, please reach out anytime.
Anything involving urine.
That's funny. That's the guy.
I'm your guy.
So I had a really funny situation once. I mean, it wasn't funny. It was a sexual harassment case, which is not funny ever. Yeah. It ended up being funny because this client made it seem that her boss was sexually harassing her, that they engaged in sexual relations, and she was like, this guy's an asshole. He's a piece of shit. He did all this horrible stuff to me, blah, blah, blah.
Right.
We get there to the mediation, okay? First, I told her, send me all your text messages with this guy. She sends me 6 text messages. I'm like, there's going to be something weird about this. We walk in. First thing the defense did when we walk in, They walk in with a binder this big of thousands of text messages between her and the boss saying, baby, I love you. They're in a legit, like, multiple year relationship.
Oh, yeah.
And I'm just in there, I'm like, great. All right, so what do we do at this point? And, you know, I can't get into too many details. We ended up settling because, you know, he was already married and stuff like that.
Right.
But
right.
that was the situation. So one thing I want to say to all of the people out there is that you want to let your attorney know everything, right? You think that you're helping the case by not telling us stuff. Now I'm sitting there like a damn deer in headlights, and I'm just like, what the hell do I do? And a lot of times there's nothing I can do except for, you know, stand behind the law and try to fight your case. But it's better that you're just honest with your attorney. Tell them the worst. Tell them the worst, because then I'm going to hit it head on, and I'm going to know what the heck to do.
Absolutely. The last place you want to have to deal with that is at mediation.
Yeah.
And, you know, it just puts your lawyer at a tremendous disadvantage.
It's super tough.
And it goes for both sides,
No,
right?
I agree.
So, you know, from the employer side of things, right, and I deal with a lot of sexual harassment type cases.
Yeah.
Look, there's just, you cannot, as a manager or a supervisor, have any type of relationship other than a working relationship with your subordinates. And here's the thing. A lot of people want to be friends with their subordinates.
Yeah.
So they put themselves in positions where they can end up, you know, look, don't go to strip clubs with your subordinates, okay?
Yeah.
Just don't do it. Because the people who are your friends now can end up twisting that around and making it look like you forced them to go to the strip club.
Yeah.
And I didn't want to go to the strip club, but he told me I would be, you know, a wuss if I didn't go.
Yeah.
And I mean, one of the things I deal with probably most often is male on male harassment.
Yeah.
Where somebody, you know, because they talk normal guy talk on the job.
Yeah. What's the saying? It's like, don't eat where you shit, like, type of thing.
Yeah,
I know it's horrible. That's definitely not the proper. But like, long story short is, guys, don't hang out with people you work with, which I know sounds tough. Go hang out with somebody else. Go spend time with other people. And I know these are the people you spend the most time with, but the legal repercussions are going to be, you know, a big headache later. Now, let's talk about two other things. I want to talk about, I know a lot of people, like, I truly believe that it's not exactly your successes that lead to where you are every single day, right? A lot of times, you know, Michael Jordan says, you know, he remembers the 73 shots that he missed. He doesn't remember all the game-winning shots that he made. And so what are, you know, maybe one mistake that we could learn from that got you on your path to where you are today?
Yeah, so I used to run my own business a few years back doing human resources and labor relations consulting.
Okay.
And the thing that you need to do is take your own advice, right? I'm always advising employers on making sure that they're following all the protocols, that they're, you know, when it comes to their employees, don't trust anybody. And I didn't follow my own advice and got burned very badly by an employee.
Got it.
And
don't do what I say. Don't do what I do what I say, right?
Right. And it's like, you know, and afterwards I was like, okay, that was really, really dumb.
Yeah.
But at the time, you know, every once in a while you have that little thought, maybe I should be, everything's fine.
Yeah.
It's not, okay? When it comes to dealing with people, people are capable of a lot.
Yeah.
And you have to have controls in place, even with people who have been working with you for 25 years.
Yeah.
Because you just don't
never know.
No.
And also, side note on that, there's an insurance called EPLP insurance, right? A lot of times that will cover you for those certain types of scenarios. Look into it with your insurance broker. If you're a business owner, you need to have EPLP insurance if you have any employees. It will protect you for a lot of circumstances, not all of them, but it will help a lot.
Yeah, absolutely.
Okay.
I think that's good.
So last thing I want to talk about is, what are one or two of the biggest habits that you do that make you such a high-level performer? Whether, you know, it's reading, meditating, journaling. What is something that you would like to share with us that we could discuss, or something that might be my viewers could implement in their lives?
Yeah, I think that the one thing that I've really learned, especially over the last 10 years, it is extremely important to get back to people as soon as possible when it comes to phone calls and emails. Okay. I mean, as lawyers, that's the thing that we're probably guilty of the most.
Yeah.
And I think one of the things that's made me successful as a lawyer is doing my damnedest to get back to people.
Yeah.
Even if it's just, hey, I got this.
Yeah.
I'm tied up. I will get back to you, by tomorrow at 12 noon.
Got it.
And I think that's true not just in the legal profession, but in any situation.
Yeah.
As an employee, if you ghost people, okay, then they're not going to trust you, and they're immediately going to be looking with a finer tooth comb at your performance.
Yeah.
Okay, that's one of the first warning signs. So get back to people, be responsive.
Yep.
And I think one of my biggest faults, like most people, is procrastination.
Yeah.
Right? It's very easy to procrastinate. I work much better on a deadline. And as lawyers, as we know that we often have deadlines. Just try to put yourself in a mindset where you can get a list of things accomplished. And the simple thing I do is it's very satisfying. It's just crossing stuff off a list.
Yeah.
It's so great when you just go.
Yeah, but prioritizing is a huge
Prioritizing, absolutely. But I know that a lot of people struggle with that because there's certain things that's just not very fun, right?
I agree.
And
you got to try to almost train yourself. I instead of saying I have to do something now, one thing I've been doing is I say I get to, or I'm blessed to.
That's great.
And just the way that you tell yourself something, like, because I respond to 120 emails plus a day. That's how many I get every day. And so I used to be so burdened by it, and now I say, you know what? I get to move the dial forward for all of these clients in one step or another, and it's changed my mentality behind it, fully.
Absolutely. Yeah. Absolutely.
So for you, it's fortune is in the follow-up is basically what I caught there. So you want to make sure you're always following up with people. And then secondly, when it comes to getting stuff done, make sure you prioritize the important things, put them in a list, and then just get them done. Just, look at it, focus, and get it done.
Focus, get it done. And having a list, what I find is that if I don't have that, you can get pulled in 900 different directions.
Yeah.
Right?
For sure.
Focus is so difficult for a lot of people. And that helps focus you.
Yeah.
So that by the end of the day, okay, I got this accomplished, as opposed to I got pulled to 120 emails and I had this many phone calls and I don't feel like I got anything accomplished.
Absolutely. Look, Eric, thank you so much for coming. For all the viewers today, look, this was a great podcast that really taught you about things that you need to know, things that you need to understand being an employer or an employee. Please listen to this, share this with friends, because this is a climate that nobody's ever been in before, and there was a lot of great information today. I want to let Eric give you guys some information. So if you are an employer and you do need to get in contact with him, or an employee, Eric is a great resource of information. He knows plenty of people that can help, and he can help you with most of your issues. So Eric, I'm going to let you give your contact information to everyone so they can reach out to you. Please go ahead.
Thanks. So my law firm is Cummins & White. We're here in Newport Beach. And my email address is ebecker, Becker, at cwlawyers.com. My phone number at the office is 949-852-1800. You can certainly find me on LinkedIn. I do post short videos called the Employer's Minute that addresses various employment-related topics. So I also have an email list where I send out email blasts when there are important developments in employment law. And certainly if you want to shoot me an email, I'll make sure you get on my list and get important developments as they occur.
All right, fantastic. Well, thank you guys for chiming in to the Nasty Truth podcast, where we're giving you all kinds of information to help you with your everyday lives. We look forward to seeing you soon. God bless, and thank you very much.
Thank you.
Nasty.